Welcome to this CPD, which is being hosted by Level 22 Chambers. My name is Nicholas Olson. I'm a barrister in Chambers specialising in defamation and privacy law. And the topic of this CPD is preventing damaging disclosures with injunctions. When I proposed the CPD topic to Chambers staff, I promised them a photo of my cat, Louie, in a bag to illustrate some slides. But what I didn't reckon with when I made that promise was that if the cat's not in the bag, it's quite difficult to make it go in if it doesn't want to. Which brings us to the importance of obtaining interlocutory injunctive relief, or as I've put it in the title, keeping the cat in the bag. Because once the cat gets out of the bag, or once a publication happens, the damage is done. Once a secret gets out, it can't be taken back. Confidential information loses its value once it enters the public domain. It's sometimes supposed that damages are an adequate remedy for the publication of defamatory material, but even this doesn't really reflect practical reality, particularly in the age of the internet. The whole thesis of awarding damages in defamation cases is that the size of the damages award serves as a marker to the public of the falsity of the defamation, and in that way helps to restore the plaintiff's reputation. But if something goes viral online, the likelihood that a judgment of the federal court or the Supreme Court or the district court will get anywhere near as much traction and publicity as the original publication is, I would suggest, a polite fiction. In almost every case, the client's interests would ideally be best served by preventing the publication from happening in the first place. And so the question for us this evening is, in what circumstances is that possible? And how do you go about it? The purpose of this seminar is not to go over the basic principles of interlocutory injunctive relief, which most lawyers would be familiar with from other causes of action, but to examine how those principles apply particularly to the restraint of publication. Because, as we will see, this is a special jurisdiction which is influenced by particular public policy considerations, mainly the public interest in freedom of speech. Now, freedom of speech is one of those topics that tends to be used often as a bit of a slogan. People talk about freedom of speech as though the meaning and the content of the expression are obvious. They may be perhaps influenced by the kind of rhetoric that attaches to the First Amendment in the United States context. But in a common law context, it's important to appreciate that this is a concept with real limits, and it's quite a restricted concept. And it's pretty well summed up by a quote from Justice French when he was a judge of the Federal Court in Brown and the Classification Review Board, where he said, "A person may say and write what he pleases, except insofar as he may not." Freedom of speech, like most liberties in the common law tradition, is really comes down to this proposition, that people are free to do anything subject to the provisions of the law, to the extent that the law prohibits something. Freedom of speech is an underlying assumption of the common law, but it doesn't have the status of a positive right. And it's subject to many restrictions, including liability for defamation, but also copyright, discrimination legislation, breach of confidence, privacy legislation, and other similar causes of action. So what we can draw from this is that the common law doesn't regard any and all forms of speech as being in the public interest. It depends on the particular characteristics of the speech in question. And freedom of speech is generally regarded in the common law as just one value which is to be measured and weighed against other legitimate public interests. Where the common law does adopt a more robust view of speech, however, and relevantly to the discussion tonight, is on the issue of prior restraint. As Chief Justice Gleeson and Justice Crennan said in Australian Broadcasting Corporation and O'Neill, which is one of the leading judgments on this topic, it's one thing for the law to impose consequences in the case of an abuse of the right of free speech, but it's another matter for a court to interfere with the right of free speech by prior restraint. That is, intervening to stop somebody from exercising freedom of speech in the first place. And that, of course, is what is implicated when we talk about applications for interlocutory injunctions. This special treatment of prior restraint really needs to be understood in an historical context. The background is that in early modern England, in most European states until the 18th century, the press was licensed by the government. So you weren't allowed to publish any form of written material without a government license. And in England, at least, unauthorised publications were punished quite strictly by a body called the Star Chamber. Press licensing legislation came to an end at about the same time that parliamentary sovereignty and supremacy became really entrenched as a concept in England in the late 17th century and the early 18th century in the context of the Glorious Revolution. And the reluctance that courts have shown to exercise prior restraint of publication really reflects a reluctance on the part of courts to reinstate that licensing system that was abolished in the 17th century, a reluctance by courts to exercise the powers of a censor. And I think it should be enough from that summary to see that what is underlying this special attitude to prior restraint is really matters of old history that have very little to do with the present political or legal or social context of Australia, but it does, as we will see, continue to inform the jurisprudence. Now, when a client approaches you concerned about a forthcoming publication of damaging material, whether it be defamatory material or a disclosure of private or confidential information, the first task of a legal advisor will be to identify the cause of action or causes of action that may be available to the client, because you don't get an injunction in the air. The injunction has to be based on a legitimate claim to final relief based on some recognised cause of action. And the first and perhaps most obvious candidate would be a cause of action in defamation. This is a cause of action that has four elements. The first thing you need to prove is that the defendant has published or proposes to publish something about the plaintiff to third parties. You need to prove that that material will identify the plaintiff, that is, that a person would reasonably understand that the material was about the plaintiff. Third, you need to prove that it conveys some defamatory meaning, that is, a meaning that would cause ordinary reasonable people to think less of the plaintiff. And fourth, you need to prove that the publication caused or is likely to cause serious harm to the plaintiff's reputation. Now, the possibility of injunctions being granted for defamation cases arose quite late in the development of the common law, only after the judicature system was established at the end of the 19th century. And that's because prior to that, common law courts didn't have the power to grant equitable remedies like injunctions. And equitable courts didn't have jurisdiction to hear defamation cases. But when the administration of law and equity was fused at the end of the 19th century, courts began to grapple with the principles on which injunctive relief should be available in defamation cases. And the first significant case in which that was considered was a matter called Coulson and Coulson. And what was held in that case was that the jurisdiction to exercise, to grant interlocutory injunctive relief in defamation cases should only be exercised very rarely and only in the clearest cases. And it was said that in order to justify the court granting an injunction, it must come to a decision upon the question of liable or no libel before the jury decided whether it was a libel or not. And that the court must also be satisfied that in all probability the alleged libel was untrue, or if written on a privileged occasion that there was malice on the part of the defendant. And because of the difficulty of being satisfied of any of those matters on an interlocutory basis, the court held that the jurisdiction should only be exercised very rarely. The next case, which is probably the most famous one in this field, is Bonnard and Perryman. And that was another decision of the English Court of Appeal, where the court reiterated the matters that were considered to be significant in Coulson and Coulson, and also added freedom of speech as an important consideration. And the court held that until it is clear that an alleged libel is untrue, it is not clear that any right of the plaintiff has been infringed. And the importance of leaving free speech unfettered is a strong reason in the case of libel for dealing most cautiously and warily with the granting of interim injunctions. Now, pausing there, this notion that an applicant for injunctive relief needs to satisfy a court that it is clear his or her rights have been infringed doesn't reflect the ordinary principles on which that relief is granted. Practitioners who are familiar with interlocutory injunction applications would know that the two questions that need to be, the two issues that need to be established are first whether there is a serious question to be tried, and the second is the balance of convenience. But proving a serious question to be tried doesn't by any means require the plaintiff to prove a certainty of entitlement to final relief or even a high probability. But that wasn't the basis on which cases like Coulson and Coulson and Bonnard and Perryman appear to have been decided. The court appears to have suggested that a much higher standard of proof was required. And subsequent English decisions have treated these cases, and particularly Bonnard and Perryman, as authority for a rule that interlocutory injunctions should not be granted in defamation cases if the defendant asserts that they intend to defend the claim on a basis such as truth or fair comment, unless the court is satisfied that it's clear that no defence would succeed at trial. This was also for a long time the view that was taken in Australia, but in 2006, the matter of Australian Broadcasting Corporation and O'Neill came to the High Court. O'Neill was, to put it mildly, an unusual and extreme case. Mr. O'Neill was serving a life sentence for the murder of a child. He later confessed to murdering a second child. And the ABC was intending to publish a documentary which suggested that Mr. O'Neill was responsible for kidnapping and murdering the Beaumont children from Adelaide. Somewhat remarkably, Mr. O'Neill was successful in the Supreme Court of Tasmania and the full court of the Supreme Court of Tasmania in obtaining an interlocutory injunction to stop the broadcast of that documentary on the basis of defamation. And the ABC appealed the case to the High Court. Now, a majority of the High Court allowed the appeal. The majority held that defamation is not an exception to the ordinary principles of interlocutory injunctive relief, and that the principles in Bonnard and Perryman don't have the status of a strict rule. the court reiterated the question is first whether there's a serious question to be tried, and second, whether the balance of convenience favours the granting of injunctive relief. But the court recognised that in applying those principles in a defamation case, the sorts of factors identified in Bonnard and Perriman remained not just relevant but significant considerations, particularly the importance of freedom of speech and the undesirability of prior restraint. And the error that the High Court identified in the judgments of the Tasmanian courts was first the failure to give sufficient weight to freedom of speech, and second, and perhaps unsurprisingly, the fact that Mr O'Neill was a person of no reputation to be vindicated in any defamation case. He was, after all, a convicted and self-confessed child murderer seeking to restrain the publication of a documentary accusing him of murdering different children. The case was perhaps an unusual vehicle to go to the High Court for any serious reconsideration of the principles applicable in this area of law, but there you have it. So, following O'Neill, the principle can be stated in these terms. Defamation is not a special case. It's subject to the ordinary rules of interlocutory injunctive relief. Matters such as freedom of speech are merely relevant considerations. But stating the proposition at that level doesn't really reflect the reality of the way that courts approach these applications. And even following O'Neill, the general attitude of courts is that interlocutory injunctive relief in defamation cases should only be granted very rarely. And it takes something fairly extreme, such as a case of blackmail or an obviously malicious or demonstrably false publication, to attract interlocutory injunctive relief in this area of law. So the take-home message for practitioners is that if defamation is all you've got, if you can't bring the client's case within some other cause of action, the advice that you need to give your client is that the prospects of success are extremely guarded and that the application will probably fail. I must say, for my part, I find the reasoning in Coulson and Coulson, Bonnard and Perriman quite unsatisfactory. And I would suggest that the approach that courts have adopted of exercising exceptional caution in these cases really isn't warranted by principle. Freedom of speech, as I've said, is a qualified freedom at common law. The common law does not recognise, and there's no support for the proposition at common law, that there is a public interest in any and all speech. It depends on the qualities of the speech in question. And there are statements in both the High Court and the House of Lords to the effect that there is no public interest in the publication of misinformation. That being so, it's difficult to see why it would be appropriate in considering interlocutory injunctions to speak about freedom of speech in the abstract without regard to the particular characteristics of the publication in question. A more intellectually satisfactory approach, in my submission, an approach more consistent with principle, would be to certainly treat freedom of speech as a relevant consideration, but to assess the weight which ought to be accorded to it in light of the particular characteristics of the material that sought to be published, the extent to which it relates to a matter of public interest, not require the plaintiff to demonstrate a certainty of entitlement to final relief, and to require the defendant to do more than simply assert that they will defend the claim, to actually inquire into the probable strength of the defendant's defences. That's not the approach that courts have taken so far, but I think that in an appropriate case, there is scope for challenge to the established principles and that those principles should be challenged. So if anyone has any cases that might be a suitable vehicle, I would welcome a brief. But the upshot is that at least on established principles, defamation is a fairly unpromising candidate for obtaining interlocutory injunctive relief. That brings us to the second cause of action, which is injurious falsehood. Injurious falsehood is in some ways similar to defamation because it seeks to vindicate the plaintiff for damage caused by words, by publications, but the elements of the cause of action are quite different. The first thing that the plaintiff needs to prove is that the defendant has published or intends to publish something to third parties. The second is that that statement that is published is concerning the plaintiff's trade, goods or business. So it has to be on that specific range of topics. Third is that the statement is false. In defamation, falsity is presumed and the defendant bears the onus of proving that the material is true as a defence. But in injurious falsehood, the plaintiff has the onus of proving that it's false as an element of the cause of action. The fourth thing is malice. The plaintiff has to prove that the defendant was motivated by malice in publishing the statement, and we'll turn in a moment to consider what that means. And the last thing is actual loss. The plaintiff needs to prove that he's suffered actual loss or is likely to suffer actual loss as a result of publication. Freedom of speech is not irrelevant to the court's assessment of whether to grant an interlocutory injunction in an injurious falsehood case. But the cases don't support the proposition that exceptional caution is required in injurious falsehood cases on free speech grounds. It's quite difficult to see at a level of principle why that should be so, given that the imposition on freedom of speech when an interlocutory injunction is granted is more or less the same, whether the cause of action is defamation or injurious falsehood. But that is the reality of the approach that courts have taken. And so typically what an applicant for injunctive relief would seek to do, where what is an issue is the publication of reputationally damaging material, is try to frame the cause of action as one in injurious falsehood rather than defamation, because it opens up the possibility of injunctive relief without special burden in defamation of the weight that's attached to freedom of speech. Now, there's limits to the extent to which you can shoehorn what is really a defamation case into an injurious falsehood case. The first is this proposition that in injurious falsehood, you need to demonstrate a false statement concerning the plaintiff's trade, goods or business. If it's not about trade, goods or business, the plaintiff's claim will fail. So there's an entire universe of subject matter which is commonly litigated in defamation concerning the personal conduct of a person, which is unlikely to fall within the purview of injurious falsehood. Now, you may be able to characterise an imputation about the client's personal conduct as something that could impact on their employment or on their business relationships, but outside those scenarios, imputations about personal conduct won't be able to be characterised as an action in injurious falsehood. In other ways, the concept of a false statement concerning trade, goods or business can be a little bit broader than what needs to be proved in a defamation case. In order to prove that something is defamatory, you need to prove that it would cause ordinary reasonable people to think less of the plaintiff. But there is a category of statements that may be false and may cause damage without actually causing anybody to think less of a person. And the characteristic example of that is saying that a person has gone out of business. There's nothing defamatory about that. People go out of business all the time, and it doesn't impute any misconduct or moral wrongdoing or incompetence necessarily. But merely saying that somebody has gone out of business, if it's not true, is likely to cause damage to their business because customers will go elsewhere. So that is a statement which probably couldn't be litigated as defamation unless there was some further aspect to the statement than just saying that the plaintiff had gone out of business. But it could be actionable as injurious falsehood. Generally, though, outside examples like that, it's the kinds of things that could be actioned as injurious falsehood would be narrower than the kinds of things that could be actioned as defamation. The second limitation is the necessity to prove falsity. And this, depending on the facts, may not be an insignificant forensic obstacle, even at the level of proving a serious question to be tried. The third is the necessity of proving malice. Malice is a very misunderstood concept in the law of injurious falsehood and in the law of defamation. It doesn't mean that the defendant doesn't like you or that the defendant is acting with spite or ill will. What it means is a dishonest or improper motive for publication. It means a lack of good faith. Now, the usual way of proving that is to show that the defendant published something which they knew was false. Actual knowledge of falsity is pretty much universally inconsistent with a proper reason for publishing. You could also prove that the defendant was recklessly indifferent to the truth or falsity of what they were publishing. But it wouldn't be sufficient to show that the defendant was merely careless or negligent. That doesn't rise to the level of malice. And courts regard malice as a serious allegation which calls for a high degree of proof on Briginshaw principles. So this is where most interlocutory injunction applications on the basis of injurious falsehood would fall down, particularly in media cases. It's quite difficult forensically to show, particularly in the context where this will usually come to a practitioner as an urgent application where you need to get across the facts in a very short period of time. It's usually quite difficult to show impropriety of purpose, particularly against a professional publisher. What I would usually advise a client to do, particularly in media cases, to try to improve the prospects of obtaining interlocutory injunctive relief is this. Normally, in media cases, these applications come about because a journalist has put pre-publication questions to your client. This is a normal matter of journalistic practice that before publishing adverse material about a person, the journalist will put those allegations to the subject and give them an opportunity to comment. In reality, at least in my experience, journalists usually do this very late in the piece, and usually at a time when they've already written or substantially written the story. And the request for comment is often the last thing that happens before the matter goes to print or goes to air. And because the story has in all likelihood already been written, or at the very least the angle has been decided upon, a client's answers to a request for comment often make little or no difference to the content of the final publication. And this is often treated as a bit of a box-ticking exercise. And there was some quite telling evidence in the Lerriman case about that, where there was evidence that the producer had joked with Brittany Higgins about 5 minutes not being enough time for Bruce Lerriman to comment, but 10 minutes being good enough, which is sort of eloquent of the attitude that was adopted to the exercise in that case. But this presents an opportunity for plaintiffs practitioners. What you can do when faced with pre-publication questions, at least in an appropriate case, if your client has something useful to say, is provide as much information as possible in response to the questions, and actually to overload the journalist with information, and then request their undertaking to withhold from publication until that material has been considered and until further questions have been put to the client in light of that material. And if an undertaking along those lines isn't given, that is at least some evidence that you can point to in court to at least invite an inference that the journalist is reckless as to the truth or falsity of the material they're seeking to publish. The suggestion that they're turning a blind eye to information which may contradict the proposed story. That it's perhaps a high risk, high reward strategy. As I said, the client actually needs to have a good story to tell in order for that strategy of overloading the journalist with information to work. They often don't have a good story to tell. And it's by no means certain that even in that scenario, a court would be prepared to draw an inference that the journalist was acting recklessly, but it's at least something to hang on to. So what we've dealt with so far are causes of action in relation to the publication of false material, false and damaging material. What we need to consider now is what can be done when what is threatened to be disclosed is true material about the plaintiff. And this is where we come to the territory of breach of confidence and invasion of privacy. And I think it's useful to consider these two causes of action together because they're in some senses complementary, or their limits are complementary. The elements of the cause of action for breach of confidence are these. You need to identify the information that you say is confidential with some precision. You need to explain why that information is confidential, why it has the necessary quality of confidence, as the cases say. You need to prove that that information was imparted to the defendant in circumstances which imposed an obligation of confidence on the defendant. And you need to show that there's some actual or threatened misuse of the information. Now, it's that step of showing that the defendant received the information in circumstances which put them under an obligation of confidence, which is often the difficult part. If the defendant came into possession of the information not knowing that it was confidential, or because the information had entered the public domain, the defendant wouldn't be under any obligations in relation to the use or misuse of that material. So how do you prove that there was an obligation of confidence? The first and most obvious situation is where the information is confided directly to the defendant, subject to an express or implied expectation of confidentiality. But more generally than that, an obligation of confidence is imposed wherever a person receives information which he or she knows or ought to know should be regarded as confidential. And that can extend to third-party recipients of the information who weren't the original confidants. When would an inference of that kind be drawn? A court might conclude that the recipient ought to know that the information is confidential if it was disclosed to them in circumstances where they were aware that the person disclosing it was breaching confidence. For example, if it was a journalist receiving a tip-off from an employee of a company about affairs of the company, or a director about material that had come before the board of the company, it would be not difficult to draw an inference in those circumstances that the defendant was on notice of the possibility, that the journalist was on notice of the possibility that their source was breaching confidence in disclosing that information. But the inference might also be drawn simply on the basis of the nature of the material in question. So things like private text messages, private correspondence, private emails are all generally regarded in our society as confidential. And there is some legislative support for that too in things like the surveillance devices legislation. Or consider things like medical records, tax records, legal documents. When the information in question is of that nature, there would usually be at least a serious question to be tried as to whether the defendant was on notice of the confidential nature of that information, simply based on the kind of information it was and the fact that that sort of information is ordinarily confidential. We now, as of June last year, also have a statutory tort of serious invasion of privacy. Privacy and confidentiality are related concepts, but they're not necessarily the same thing. For example, a trade secret is a quintessential example of confidential information, but it's, at least as a matter of first impression, difficult to characterise it as private information. If we understand private information as things which are sensitive to us on a personal level and which impact our dignity and our sense of self, you really can't describe a trade secret as implicating those kinds of interests. On the flip side, if you took a photograph of a person sunbathing topless on a beach, that would be an invasion of her privacy. But it would be hard to characterise that as confidential information if this is happening on a crowded beach with hundreds of people around. So these are different concepts, and practitioners can't proceed on the basis that in any case where a cause of action for breach of confidence is available or where confidential information is implicated, privacy principles may equally apply. We're also, unfortunately, in a position where the tort that Parliament has given us in Schedule 2 of the Privacy Act has some very significant limitations. The elements of the cause of action are these. First, you need to prove that the defendant invaded the plaintiff's privacy. And an invasion of privacy can involve either of two things. The first is intruding upon the plaintiff's seclusion, and the second is misusing information that relates to the plaintiff. Now, an intrusion upon seclusion might be, for example, the New Zealand case of C in Holland, where the defendant was filming his flatmate through a hole in the ceiling while she was in the shower. That's an intrusion upon seclusion. It doesn't matter in an intrusion upon seclusion case what you do with the information that you collect. It's the collection of the information itself, the intrusion upon the seclusion, which is the actionable wrong. And even if you don't publish the material or use it in any way or disclose it, the tort on that limb has still been committed. Misuse of information includes collecting it, using it, or disclosing it. And it's a fairly broad concept. Now, the second thing you need to prove is that a person in the position of the plaintiff would have had a reasonable expectation of privacy in all of the circumstances. Factors which are relevant to the assessment of that reasonable expectation are set out in the legislation. I've set them out in the paper that accompanies this CPD, and I won't rehash them here. But one interesting aspect of the test is that it is a relevant consideration are the personal attributes of the plaintiff, particularly cultural aspects of the plaintiff. So, for example, for a person of Christian Caucasian heritage, there's no reasonable expectation of privacy in relation to a woman's head being uncovered. But if the plaintiff was a Muslim woman, an observant Muslim woman, different considerations might apply, because a person of that faith may have a reasonable expectation of privacy in relation to depictions of their head being uncovered. There are further relevant considerations, as I say, they're set out in the legislation and the paper. The third element is intent. The plaintiff needs to show that the invasion of privacy was intentional or reckless. The legislation is a bit unclear as to this, but my view is that what needs to be proven is that the act which constituted the invasion of privacy was intentional or reckless, not that the defendant necessarily intended to invade the plaintiff's privacy. The fourth thing that needs to be proven is that the invasion of privacy was serious. And the last thing is that the public interest in the plaintiff's privacy outweighed any countervailing public interest. And the legislation specifically states that the public interest in freedom of speech and freedom of the press are countervailing public interests. It's not, there's no basis in the text of the Privacy Act to suppose that the public interest in freedom of speech would be treated as a preponderant or determinative consideration in privacy cases in the way that it has been in defamation cases. But certainly it will be a relevant consideration and is likely to carry substantial weight depending on the facts. One very significant limitation on this tort, however, is that there is a blanket exemption where the invasion of privacy involves the collection, preparation or publication of journalistic material by a journalist or the employer of a journalist or a person assisting a journalist in that person's professional capacity. And this means that in any case involving media publication or threatened media publication, the cause of action for serious invasion of privacy will almost certainly not be a viable option for obtaining interlocutory injunctive relief. There may be some scope in future cases for arguing about whether particular media publications actually fall within the journalism exemption. So there was a case of Groth and Herald and Weekly Times in the federal court late last year that concerned an allegation that the Victorian MP and former tennis player Sam Groth had an inappropriate sexual relationship with his now wife when she was underage. And Mrs. Groth sued the Herald and Weekly Times for serious invasion of privacy for publishing details about her sexual life and her relationship with her husband. The argument in that case was that the publication didn't fall within the journalism exemption because there was no baseless revelations, in inverted commas, about the circumstances in which the Groths had originally met had no quality as news. It was mere gossip. But that wasn't an application for interlocutory injunctive relief. And given the breadth of the journalism exemption, although a plaintiff might ultimately prove that it doesn't apply, it would, in almost every conceivable case, be difficult, if not impossible, for the plaintiff to establish that there was a serious question to be tried in relation to that issue, I would suggest. One final thing to bear in mind when it comes to interlocutory injunction applications in relation to private and confidential information is that the actionable wrong is misuse of the information, not merely disclosure of it. The concept of misuse is broader than disclosure. So one scenario that may arise and has arisen in my practice is where a journalist, it becomes apparent through, for example, pre-publication questions that a journalist has access to private or confidential information of the plaintiff, and that information is being used by the journalist as a springboard for further research. The information, the actually confidential information, might not ultimately be disclosed in the final publication. But if it has been used in the process of research, that, at least arguably, is a misuse of the information, which could be restrained by injunction. So to sum up, the task that confronts a practitioner when approached by a client in a panic because they've received questions from a Today Tonight journalist or from Nick McKenzie, or they're being blackmailed by an ex-lover or a disgruntled former employee, is it's a challenging one because, as I say, these applications typically come on very urgently, and the task of the practitioner is to identify a way through, identify a cause of action that meets the facts of the case, which will provide a platform for interlocutory injunctive relief. And it's made more difficult by the fact that basic principles, such as the weight that's attributed to freedom of speech, are not applied evenly between the different courses of action. We've seen that the approach in defamation, for example, is substantially different from the approach in injurious falsehood, even though there's a lot of commonality between those courses of action. It's an area where practitioners need to be able to advise quickly and act quickly, and hope that with a CPD like this, it will contribute to developing a stronger working understanding of those principles to assist in giving that advice on an urgent basis. So thank you all for attending, and I'm happy to take any questions. No? No questions online? All right.
Sorry, can I just ask, I mean, very briefly, but
yeah.
Is it then okay for people who are writing an article to be picking through someone through the ceiling? Isn't it what you just said? This is an exemption?
Oh,
so that's towards.
No, the New Zealand case I mentioned, C in Holland, wasn't a media case. It was one flatmate spying on the other flatmate. But I think what you're asking is if a journalist had access to plainly private information about a person, the tort doesn't assist, no. And the question then would be whether you could bring the cause of action within the ambit of breach of confidence, because the breach of confidence action isn't subject to those limits. In many cases you can. If it's information which is not, which a plaintiff has kept secret and not widely disclosed, you could characterise it as confidential and not merely private. But what I was seeking to explain earlier is that there may be cases around the edges of confidentiality or privacy which don't overlap. For example, the showering case. Everybody showers privately. So if you had footage of somebody in the shower, that could almost certainly be characterised as confidential information. But sunbathing topless on a public beach where there are hundreds of people around is a different situation. But the journalism exemption in the privacy tort is very unsatisfactory. And it wasn't, there was public consultation on the legislation, but there was no public consultation on that exemption, which makes it especially unsatisfactory. And it's very difficult to see any reason in principle why journalists should be given such an exemption, given that when they infringe privacy, that's where the most damage is likely to be caused. And one only has to look at what happens with the English tabloids, for example. It goes to illustrate my point about the need for a practitioner to weave a way through the different causes of action available and navigate the limits and restrictions on each of them. You have any other questions? No? All right. Well, thank you all.